And so the host each year then picks the distinguished scholar or jurist to bring, to invite into New Zealand with the sponsorship from the New Zealand Law Foundation. And we're quite fortunate this year. Victoria University Wellington has been able to entice Professor Jane Ginsburg to come and spend time with us. For those of you who haven't read her bio or some of her material on Through the Joys of Google, Professor Ginsburg is a Morton L. Genklo Professor of Literary and Artistic Property Law at Columbia University School of Law in New York City, as well as the Faculty Director of the Kernosian Center for Law, Media, and the Arts. She teaches in a range of areas from first-year legal method. We're going to take away a little bit of the view, perhaps to improve the quality of the PowerPoint on the screen. She also, of course, teaches in copyright and trademark law, is the author or co-author of casebooks in all three of these subjects, as well as co-author of a text on copyright concepts and insights with Professor Robert Gorman, published by Foundation Press 2 years ago, with Professor Sam Rickardson, entitled International Copyright and Neighboring Rights, the Berne Convention and Beyond, from Oxford University Press in 2006, as well as a number of other books on domestic or international copyright and trademark law. And along with Professor Dreyfus and Professor François de Saint-Monté, she's a co-reporter for the American Law Institute project on intellectual property, principles governing jurisdiction, choice of law, and judgments in transnational disputes. She comes to us with backgrounds and degrees from University of Chicago before doing her JD in law at Harvard, and then subsequently a Diplôme des études approfondies, and then a Doctorate of Law from University du Paris 2. So she is a corresponding fellow of the British Academy, a member of the American Philosophical Society, and an honorary fellow of Emmanuel College, University of Cambridge. And as I say, we're delighted to welcome her here today. Now, this is the second of her 2 talks today. She's already done a seminar earlier today, and so now we're delighted to have her sing again for the supper she's not yet been fed. Professor Jane Ginsburg.
Thank you very much. I don't think that's necessary. It is a great pleasure to come for the first time to this law school, and it's really a beautiful university. I think I can fairly say that now that I have been to all 6 national law schools, that this campus is the most lovely campus that I have seen in my time here in New Zealand. And of course, I'm very happy to provide an opportunity for procrastination for any of you who are supposed to be marking. So thank you very much for notwithstanding that, for coming to this lecture. I would like to set aside, because it reserves some time for rebuttal, to provide some time for discussion, for question and answer after the formal part of this presentation. So, as to the formal part, access to all the world's knowledge is an ancient aspiration. A less venerable but equally vigorous universalism strives for the borderless protection of authors' rights. Late 19th century law and politics implemented copyright universalism. 21st century technology may bring us the universal digital library, and with it, a clash of utopian yearnings if culture freely accessed comes to mean culture unremunerated. Does the universal digital library of the near future threaten copyright holders, particularly publishers? Lest we sound too soon the dirge for traditional publishers and newer commercial distribution intermediaries, we should remember that digital media may enhance access to culture, but culture freed from its former masters may not yet be free. Access triumphalism may bring us not the universal digital library, but the universal digital bookstore. In this talk, I will first evoke two utopian goals: universal access to knowledge and universal authors' rights. The former implied a curator-custodian, a public institution that would gather, systematize, and make available the world's knowledge. The latter enforced private prerogative through the international recognition of authors' property rights that arise from their creativity or are justified by the public benefits that creativity bestows. Creators and custodians of knowledge long pursued complementary aims, despite occasional skirmishes between copyright owners and libraries. That now may be changing. In the last part of this talk, I will address the clash of utopias epitomized by the Google book scanning program and the legal responses it has inspired. Finally, as we query whether through mass digitization libraries will replace publishers or vice versa, we should not lose sight of the authors, who are both copyright's raison d'etre and the necessary forebears of libraries, for without works of authorship to stock the collection, there is nothing to curate. Let's start with a cook's tour of custodians and curators from the Library of Alexandria. What's the talk of this title's invocation of Hypatia, the legendary librarian of Alexandria in late antiquity, to the Renaissance and the late 19th century, to new technologies of the 20th century, culminating in the recently debuted Digital Public Library of America. Utopian dreams of a universal archive of knowledge almost always refer to the Library of Alexandria. It is often described as a universal library. According to a 2nd century BC document from the Jewish community of Alexandria, its mission was to collect all the books in the world. Commentators throughout antiquity and early Christianity similarly evoked the comprehensive aspirations of the library. The American classicist and historian Roger Bagnall has described the persistent power of the idea of the Library of Alexandria. He wrote, "The Library of Alexandria bequeathed the image of itself, the idea of a large, comprehensive library embracing all of knowledge. Its grip on the minds of all who contemplated it was already in antiquity as great as it was later. Although the authors whose works survived antiquity told posterity little of any concrete substance about the library, they transmitted its indelible impression on their imaginations." Moving ahead some 1,500 years, with the advent of the printing press and the vast increase in the range of books, new and old, that it enabled, no single place could unite all literary and scientific productions. The urge to comprehensive knowledge did not abate, however. Rather, it spawned a new kind of collection and systematization, the thematic catalog. For example, in 1515, the Florentine man of letters and bibliographer Anton Francesco Doni published in Venice his Libraria, subtitled, and my translation is under your control, in which are inscribed all the vernacular authors with 100 discussions of them, as well as all the translations made from other languages into ours, and an index generally laid out according to the customs of booksellers. That's all the text before you get to con privilegio. Privilegio is a kind of pre-copyright. Doni seems to have become obsessed with his task, for a subsequent printing from 1550 tells tells us that it is newly reprinted, corrected, and with many things added that were missing. In 1557, the indefatigable Doni produced a second edition, featuring an even more prolix subtitle, informing us that his work now consists of 3 treatises, and stating in part that the second treatise includes Doni's more recent listings of the authors, the works, the titles, and the substance, and assures us that his book is necessary and useful to all those who need knowledge of our language and wish to know how to write and think about all the authors, their books, and their works. The Libraria went through further editions even following Doni's death, as successive publishers sought to satisfy a vigorous demand for this kind of contemplation. Thus, a 1580 edition tacks on to Doni's run-on title the information that to the current printing have been added all the vernacular works published in the last 30 years in Italy. However, in a punctilious nod to the Counter-Reformation, the 1580 edition's subtitle also cautions, and having removed all the prohibited authors and books. We skip forward to the end of the 19th century, where we encounter Belgian lawyer and visionary Paul Otlet, a spiritual descendant of Doni, but by a power of 10 at least. He imagined a universal book of knowledge, in which all knowledge, all information, could be so condensed that it could be contained in a limited number of works placed on a desk, therefore within hand's reach. He obviously had not attained that perfection at the time of this picture. And indexed in such a way as to ensure maximum consultability. In this case, the world described in the entirety of books would really be within everyone's grasp. The universal book, created from all books, would become very approximately, he declared, an annex to the brain, a substratum even of memory, an external mechanism and instrument of the mind, but so close to it, so apt to its use, that it would truly be a sort of appended organ, an exodermic appendage. Now, this sounds like science fiction, only today's futurists would house the information in an endodermic appendix, such as a brain-embedded microchip to which information could be uploaded a la Matrix. Otlet's frenzied efforts to capture and catalog all the world's knowledge produced real information processing innovations too. He invented the great search tool of libraries of yore, the once ubiquitous system of index card files on rods in pull-out drawers in library cabinets. I don't know how many of you admit to remember it. And with over 12 million of those index cards, he created an archive he called the Mundanium, which he saw as a successor to the Library of Alexandria, the Summa of Aquinas, the Encyclopédie, and all the world's great libraries, museums, and world expositions put together. We might perceive it as a kind of Google avant la lettre. Otlet declared that the Mundanium is about gathering, condensing, classifying, coordinating, finally to represent and to reproduce. The Mundanium still exists physically in Mons, Belgium, and virtually at www.mundanium.org. Perhaps fittingly, it benefits from Google's sponsorship. Otlet also co-invented microfilm, a new technology that far exceeded his principal bibliographic efforts. This new, convenient, and compressed storage medium could enable libraries both to preserve fragile volumes and to increase their collections while occupying far less shelf space. With microfilm, we go beyond summarizing the contents of books to return to the original utopian aspiration of gathering all the world's books themselves. But at this point, the visionaries address the possibility that all this content could come within the grasp not only of institutions, but also of individuals. In 1945, Vannevar Bush, who as director of the wartime U.S. Office of Scientific Research and Development was one of the forces behind the Manhattan Project, contemplated the revolutionary promise of microfilm. In a noted essay published in the Atlantic magazine in the closing months of the Second World War, Bush proposed a Memex, a private device for information storage and retrieval that by responding to and storing the associations that the human mind produces would transcend what he called the artificiality of systems of indexing used in libraries. Bush described the device and its capacities as follows. A Memex is a device in which an individual stores all his books, records, and communications, and which is mechanized so that it may be consulted with exceeding speed and flexibility. It is an enlarged, intimate supplement to his memory. Note the memory supplements metaphor, recalling the Autletian exodermic appendix of the mind. Mechanical storage adjuncts to the brain join the Library of Alexandria as a top metaphor for the bibliographically inclined. Bush continued, it consists of a desk, and while it can presumably be operated from a distance, it is primarily the piece of furniture at which he works. On the top are slanting, translucent screens on which material can be projected for convenient reading. There is a keyboard and sets of buttons and levers, otherwise it looks like an ordinary desk. In one end is the stored material. The matter of bulk is well taken care of by improved microfilm. Only a small part of the interior of the Memex is devoted to storage, the rest to mechanism. Yet if the user inserted 5,000 pages of material a day, it would take him hundreds of years to fill the repository so he can be profligate and enter material freely. From the photographic impressions of microfilm to today's digital scanning, the prospects for the great and universally accessible compendium of content are en route to realization. Indeed, the Digital Public Library of America launched in April 2013. At a lecture at Columbia Law School in the spring of 2012, Robert Darnton, Harvard University librarian, renowned historian of the book, and leading instigator of the DPLA, declared, "We know that we want the DPLA to serve a broad constituency, not just faculty and research universities, but students in community colleges, ordinary readers, K through 12 school children, seniors in retirement communities, anyone and everyone with an interest in books." Darnton is confident that the DPLA will overcome any technological and funding impediments. There remains the stumbling block of copyright. Many of those interesting books are still under copyright, and sorting through the rights clearance may prove daunting, if not intractable. But we will return to those problems after we consider how copyright, with its own universalist aspirations, comes into the picture. Before copyright, the printing press gave rise to printing privileges issued by territorial sovereigns to protect and encourage investment in the material and labor of printing. But each sovereign's power to protect the nascent book trade extended only to the limits of its realm. Publishers, or authors, for authors too obtained privileges, who envisioned multi-territorial distribution would seek multiple privileges, for example, from the French king, the Holy Roman Emperor, and the various Italian principalities. But papal privileges, of which this is one, defied territoriality. They purported to cover all of Christendom, and their sanctions included confiscation of infringing copies and automatic excommunication, a truly extraterritorial remedy. We are, however, in the 16th century, and the efficacy of excommunication may not have been what once it was. Even the Pope and the privilege-granting Cardinal Secretary of Papal Briefs probably would not have expected a new canossa of legions of penitent infringers, barefoot in the snow, begging absolution and surrendering their pirate wares. So the cautious publisher or author, Ariosto among them for the Orlando Furioso, would have sought the prestige of a papal privilege, but would also have continued to petition all likely sovereigns for the special grace of an exclusive privilege prohibiting the unauthorized printing, selling, or importation of their works. By the 18th and 19th centuries, with the advent of true copyright law, that is, exclusive rights vesting in authors, exclusive rights are no longer a matter of special grace, but have become property rights justified by the author's intellectual labor, as well as by the interests of the polity. Property rationales also fueled the endeavors starting in the mid-19th century to achieve the goal of universal international protection of authors' rights. Rising literacy, both literary and musical, had by then contributed to an international market for works of authorship. But copyright owners still found their rights confined to national borders. Bilateral treaties arose to give protection on the basis of reciprocity, but obtaining coverage for multiple territories remained complex and cumbersome. Composers particularly found themselves attempting multiple simultaneous first publication in several countries in order to endow their works with local protection. International copyright concerns motivated Gilbert and Sullivan to manipulate the nationality of their work by arranging for the Pirates of Penzance to debut in New York City in 1879 because the U.S. did not then protect foreign works. Effective international protection required multinational cooperation, not only to recognize foreign works, but also to protect them on non-discriminatory terms. In 1858, the first great international Congress on literary and artistic property took place in Brussels, with over 300 delegates, including Charles Dickens, John Stuart Mill, Eugène Scribe, and Alphonse de Lamartine, among many other luminaries. The Congress declared the principle that the national recognition of the author's property in their works of literature and of art should be established in the laws of all civilized peoples. Lest one think that copyright universalism also means copyright maximalism, setting greedy copyright owners against the broader public interest, it is worth observing that the Brussels delegates also asserted, with Gallic grandiloquence, the necessity to proclaim as a fundamental principle the uniform, universal, and international recognition of intellectual property. The enjoyment of this property should be broadly guaranteed, but within reasonable limits, in order to pour into the common stock of human intelligence the treasures by which those elite spirits, after their temporary profit, receive forever the honor and the glory and the gratitude of mankind. Only the French could write like this. 20 years later, however, authors' rights remained bounded by national borders, freighted with formalities, and prey to international piracy. And so began another universalist push propelled by the outsized celebrity of Victor Hugo, who presided over the 1878 International Literary Congress in Paris. This gathering also featured the participation of Ivan Turgenev. The 1886 Berne Convention that ultimately resulted from their efforts remains the preeminent multilateral copyright treaty and the predominant expression of copyright universalism. Victor Hugo made several speeches in the course of the 1878 Congress, often at a rather high level of abstraction and an even higher level of oratory, about truth, beauty and civilization, literature, and human progress. But he also pronounced on copyright in terms echoed today by scholars such as New Zealand's Graham Austin, who remind us that authors' rights are human rights. Victor Hugo declared, "Literary property is in the public interest. All the old monarchic laws have rejected and continue to reject literary property." To what end? In order to enslave. The writer who is an owner of his literary property is a writer who is free. To take his property away is to deprive him of his independence. Like his predecessors in Brussels, Victor Hugo was a copyright universalist, but not an absolutist. "Let us establish the principle of the respect of property. Let us affirm literary property," he exclaimed, "but at the same time, let us also establish the public domain." For our purposes, tracing the evolution of universal authors' rights, perhaps the most important development in the history of the Berne Union was the revision conference held in Berlin in 1908. It established the dual principles of absence of formalities conditioning the existence and enforcement of copyright and independence of international and domestic protection. Formalities are conditions prerequisite such as registration or publication of claims or National Library deposit of copies. In the 19th century, an author would have had to have complied with the formalities of each country for which he sought protection, assuming the country of which the author was not a national extended any protection at all to foreign claimants. The 1908 Berlin revision prohibited the imposition of formalities on foreign authors altogether, and provided that union authors would be assimilated to local authors in every member state. The effect of the Berne revision was to confer copyright throughout the Berne Union, automatically and upon creation, on every convention-covered work created by an author who was a national of a Berne Union member state or first published within a member state. The Berne Union today is composed of over 165 member states, including the United States, of which I am a national, and New Zealand. As a result of the Berlin revision and subsequent U.S. adherence to the Berne Convention, the moment I created this lecture, it enjoyed copyright protection in over 165 countries outside the U.S. without any obligation that I fill out any forms or pay any registration fees to authorities in any one of those nice blue countries. This is indeed the universal coverage for which Dickens and Mill in 1858 and Victor Hugo and Ivan Turgenev in 1878 yearned. This brings us to the clash of universalist aspirations. How can all the world's knowledge, that's the folks that coined the term, including that expressed in works whose copyrights have not expired, be delivered on demand to users anywhere in the world with internet access, if the copyrights of the creators and publishers of those works are supposed to exist and be enforceable almost everywhere in the world? You may now be familiar with the general outlines of the Google book scanning program inaugurated in 2004. Google scanned the contents of participating U.S. university libraries, one of which, the University of Michigan, authorized Google to reproduce and store digital copies of in-copyright works. The other libraries had restricted Google to their public domain collection. The scanned text was converted to a searchable format, allowing users to query Google's database and retrieve, in addition to basic bibliographic information, 2 or 3 line snippets of text, setting the searched term in its immediate textual context. Google would not display a greater amount of text without agreement from the right holders. But Google did and does retain complete copies of millions of in-copyright scanned books in its database. Google also returned to each participating library a fully scanned copy of that library's holdings. In 2005, the Authors Guild brought a class action, and a group of publishers brought a separate action against Google, alleging massive copyright infringement through the copying and storage of full text and the communication to the public of snippets of text. Google boldly replied that the U.S. fair use exception to copyright sheltered its program, and all the parties began settlement negotiations. In 2011, the Federal District Court for the Southern District of New York declined to approve the class action settlement, largely because of the immense advantage the settlement would have conferred on Google relative to competitors who sought permission before scanning in copyright books. Following the court's rejection of the class action settlement, Google reached a separate settlement with the publishers, but its terms are undisclosed. With the rejection of the class action settlement that would have allowed displays of substantial portions of the book's text, Google's program with respect to unauthorized copies maintained its original guise of providing bibliographic information and displays of snippets of text in response to user search queries, as well as access to the database of scanned books for purposes of data mining. The output Google Books users encounter either eschews copyrightable expression or consists of very short extracts. Last November, the District Court for the Southern District of New York, with respect to the author's action, which continued, ruled Google's book scanning to be fair use. Several of the reasons the court gave in support for its fair use ruling evoked the book scanning program's benefits to libraries in general, beyond the provision to each supplier library of scanned copies of its holdings. Google's bibliographic information provides links to libraries and to bookstores where the physical book may be found. According to Judge Chin, Google Books has become an essential research tool. The Authors Guild has appealed Judge Chin's ruling, but in the interim, the Second Circuit Court of Appeals rendered its decision in another controversy stemming from the Google Book scanning program. Authors Guild versus HathiTrust involved the use by the University of Michigan Library of its copy of the database that Google had created from that library's collection. The Second Circuit announced a broad fair use privilege to create and store digital copies of entire books for purposes of data mining of full text. Looking at the output of data in response to search queries rather than the input of full copies of books into the database, the court found the data mining uses did not generate any output of copyrightable expression, and the nature of the use corresponded to a purpose entirely different from those covered by more conventional uses. The court therefore concluded that there was no impact of the use on the potential market for the work. That this market might be one that copyright owners would come to develop apparently does not matter. The court gave short shrift to the author's contended economic harm from lost licensing opportunities. HathiTrust and Google Books appear to be cases in which the court perceived the public benefit to be so compelling and the market harm so trivialized that the use should be free of restraint and free of charge, even if it could be licensed. The cynical might say that the courts have conscripted authors and publishers to uncompensated partnership with libraries in the pursuit of socially laudatory objectives. Returning to Google Books, the HathiTrust decision leaves the smart money betting on an affirmance of Judge Chin's decision. But it bears emphasis that the scope of the Google Books and HathiTrust programs, as ultimately adjudicated, fell far short of establishing a digital lending library of Alexandria. Google's servers may now house an Alexandrian digital storage library, whose principal beneficiary may in fact be Google. The program the courts endorsed consists largely of a magnificently performing interactive catalog of books out of print. I do not mean to belittle the data mining function, on the contrary, but we should be clear that Google's and HathiTrust's victories do not mean that either may now deliver all the world's knowledge in book form to the internet-enabled computers of would-be readers. Had the Google Books class action settlement been approved, by contrast, it might, at least in the short run, have approximated the Alexandrian aspirations of the internet-enabled, because in addition to generally providing full-text copies of copyright-expired works, it would have offered various levels of access to millions of in-copyright books. For copyright-protected books, not commercially available, out-of-print books, users would have seen up to 20% of the text under the standard preview. Moreover, users could have viewed full text of in-copyright but out-of-print works through universities and libraries, who would have obtained institutional subscriptions from Google. And non-scholarly users could have viewed full books under a special public access service provided free to public libraries and to not-for-profit higher education institutions at a specified number of terminals. Thus, Google would have partnered with libraries, not just the libraries whose collections Google scanned, to give the public access to the entire contents of in-copyright, out-of-print works. So where's the rub? Google is not a charitable institution. In addition to the competition concerns that undergirded rejection of the class action settlement, Google's dominant position presents other threats. Harvard University librarian Robert Darnton doubtless expressed the fears of many institutional librarians when he cautioned that the price of the institutional subscription from Google could have risen precipitously, putting libraries in the same kind of pricing stranglehold they complain of today with respect to the scientific journal publishers. Moreover, with or without the class action settlement and beyond the low baseline of Judge Chin's and the Second Circuit's fair use rulings, the level of access via libraries or online bookstores to commercially available in copyright books, that is current titles, depends on agreements with the right holders. If an author or publisher wishes to make her work freely available for free or against advertising revenue, she may do so with or without Google. And right holders who want to be paid have authorized Google and Amazon and others to sell ebook versions of in-copyright titles. Indeed, they were doing so even before Google began its massive unauthorized scanning. As to current titles, then, the market for electronic access via Google or others is well underway. But what about libraries? We have seen that the digital environment can sometimes put libraries in competition with publishers. But in considering ways in which libraries might compete with publishers, we have been assuming that given the choice between free access and paid access, the public will prefer free. That assumption, however, turns on equivalent levels of access. If copyright holders limit the level of free remote access that libraries may provide, and the law limits that level as well, but publishers make full text available for a fee or against advertising revenue, the commercial option may seem more attractive. I suspect that, especially among some of those here present, I am not alone in having occasionally to point to physical books to remind students that they might need to go to the library to consult these artifacts, because not everything is available on the net. As publishers or other intermediaries increase the offer of ebooks, if they do not also authorize libraries to offer remote access, the library's public may shrink to vintage scholars intoxicated by the smell of aging paper. Lest one think that the posited hybrid digital library bookstore is fanciful, let's return to Google. In Otlettian Back to the Future fashion, the Google Books Library project is subtitled An Enhanced Card Catalog of the World's Books. It offers full text of public domain books and limited or no views of in-copyright books. These restrictions may reflect the undisclosed terms of the settlement with the publishers. And the library project includes not only links to the libraries that house the books, but also links to online bookstores to buy the book. The future Alexandrian repository of digitized books, therefore, may take many forms, not all of them in line with the original public curator custodian model. Whether public or private, however, Alexandria's virtual lending library shelves need to be stocked with more than public domain works and current ebooks. The difficulties arise from books still in copyright, but which their authors or publishers are no longer making available, whether commercially or for free. The copyright term is very long. In many countries, including the US and those of the EU, but not New Zealand, it endures for 70 years after the author's death. But books' commercial life generally is far shorter. For the vast bulk of books, copyright owners may, after 5 or 10 years, have exhausted a hard copy book's likely revenue stream. I specify hard copy because a book in digital form can be offered on demand, so a publisher may keep it commercially available for individualized delivery and thus take advantage of the persistent trickle of sales the so-called long tail phenomenon promises. As a result, the problem of unavailable books may be transitional, but for now there are undoubtedly millions of out of print in copyright books existing only in hard copy format. How are those works to be digitized and disseminated? Conversion to digital format is the prerequisite to bringing these works under the aegis of the virtual Library of Alexandria, but it is not clear who can or will exercise the rights to scan and store and make full text available. Recall that Google does not make anything more than snippets available without permission. With respect to publishers, we can anticipate at least 2 problems. First, disinclination to reinvent Google's wheel by committing the resources to scanning all the in-copyright books they ever published. Second, and more significantly, for older books, the rights may have reverted to the authors, or the publisher may never have acquired the digital rights, and therefore, without reaching a new agreement with the author, the publisher can't unilaterally digitize and disseminate or authorize third parties to do so. What about authors? In addition to the resource problem, the older the book is, the harder the author or her heirs may be to find. Or the heirs may have been fruitful and multiplied. and depending on the competent national law, if the author is dead, it may be necessary to obtain a majority or even unanimity of the heirs' agreement. What about libraries? If the book is already in the library's collection, some national laws may allow the library to digitize for preservation or for making available on library premises. But it is less clear that without an applicable copyright exception, the library could digitize to make available on the scale our Alexandrian project envisions. Even if fair use is seeming quite cavernous today, we should recall that Judge Chin emphasized that Google Books promoted the sale of books because of the limited access Google offered did not enable libraries to substitute their services for remote full-text access to the scanned books. So what might an adequate library exception look like? As a first principle, with which some may not agree, libraries should not compete with publishers, or for that matter, with self-publishing authors. Ascertaining what compete with means, of course, is not an obvious endeavor. We might take library-publisher coexistence in the hard copy world as a starting point, and some publishers have indeed attempted to replicate the limitations of that world in the digital environment, for example, by imposing e-book licensing conditions that limit library provision of access to 26 loans. That number of loans apparently corresponds to the amount of wear and tear a hard copy book can sustain before the library will need to replace it with the purchase of a new hard copy. But it seems a waste of the potential of digital media to restrict its dissemination to the lesser capacities of hard copies. Library publisher agreements should give the public at least some of the benefit of the convenience that the digital medium can provide. On the other hand, the digital world also offers authors and publishers new opportunities for individualized commercialization of the backlist of books or portions of books. Free remote delivery by libraries might compromise this emerging market. As a result, it may be necessary either to forego the full potential of digital media in order to limit the number of simultaneous remote readers, or to devise a means of compensating authors and publishers for those readers. In the European Union and in New Zealand, the public lending right has long generated compensation for hard copy library lending. And national libraries in the EU member states, including the UK and the Netherlands, have taken the position that they are permitted under the public lending right to engage in e-book lending on a one-copy, one-reader basis. That question is now before the European Court of Justice on a reference from the Court of Appeals of The Hague. Libraries have not yet, however, asserted an entitlement to allow multiple readers simultaneous access to a digital file. As the EU member states address the adaptation of the public lending right to the digital environment, other countries might also consider whether to adopt similar measures. Second, the exception should favor the creation of otherwise unavailable digitized versions. As the publisher's agreement with Google suggests, it is possible to cover some of the universe of extant hard copies by negotiated agreements. The older the book, however, the more elusive a negotiated solution because the necessary parties may not be around to be represented. The copyright term is very long, so for the last 20 or 40 years, perhaps an opt-out approach combined with statutory remuneration is worth considering in order to enable public libraries to make the digital books available remotely. Third, for any exception that includes statutory remuneration, authors or their heirs should be the recipients. The law should presume that in the absence of proof by the publisher that it holds the digital rights in whole or in part, the money should go to the author. In conclusion, The digital era is bringing us a convergence of the functions of library and of publisher. The blurring of their roles has prompted some to panic that Google has gained an unfair advantage in the digital book market. But in the race to catch up, we should take care lest hastily cobbled legislation advance the interest neither of libraries nor of authors. We do not need copyright legislation that simply transposes the sloganeering that has poisoned the public debates over copyright. Whether in international, EU, or national fora, much of the discourse in the copyright field has been hair-rendingly dismal. We need to leave off the Manichaean posturing in general, and in particular, to endeavor carefully to work through the respective domains of copyright holders and public libraries, so that free, public, digital lending libraries may continue to develop, and also so that authors may reap the benefits both of broad dissemination and commensurate remuneration. Thank you.
Well, Professor Ginsburg is open for questions, comments, objections, challenges.
Outrage.
I don't hear any outrage. Yes.
Hi. So the last bit of what you said suggested that we should just pretend that everything with copyright is okay at the moment. The legal status of it should be ignored in our questions to you. Was that the intention of kind of your last couple of sentences?
What is the premise of your question?
Well, so the approach which I'm not going to take is to say that, well, copyright seems to be broken, and if we fixed it, then a lot of stuff would fall out. But let's pretend copyright's okay. It seems as though there is a third party to this discussion which you didn't mention, which is that, roughly speaking, the international community of individuals online is doing the same thing which Google is trying to do, namely scanning and presenting, albeit illegally, all the works of the world online. So whatever solution we come to with this probably needs to take into account the fact that all of this stuff is already there and available to those who are willing to ignore the current legal status of copyright. And that just means that unless copyright starts being enforced, you've got this third player sitting there which is going to severely impact the ways in which we actually get this to play out. Okay, so there's a number of pieces to the what some people call the dark net. There's a parallel universe of illegally reproduced content that people can access and retain. So you're quite right that it's not all that feasible to prevent the creation of those illegal copies. Is there anything that could be done about the dissemination of those illegal copies? So how are people going to find out about the availability of those illegal copies, even if it's done purely on a peer-to-peer basis rather than on the basis of some website that says come and get it? That's an easy target.
By Googling it.
By Google. So, but there is the problem that if the content is distributed, so that, but you can get it through a peer-to-peer network, is it feasible to attack the peer-to-peer network? Now, there have been a lot of cases about peer-to-peer networks that have produced legal victories and de facto defeats, because every time one of these networks is shut down, a new one comes up, arises somewhere. And to what extent is it just a continual process of cat and mouse? If there, to the extent that there is somebody higher up the chain, that is a point of attack. And moreover, the ISPs that provide access to, say, aggregators of links to some of this content. There is now in the EU, the remedy of site blocking is pretty well established. So you can get the links taken down, and you can block access to offshore websites in that way. But is any of this going to really make a difference? I can't be that sanguine about legal responses to technological workarounds, because the law will always be behind. Even when there's not, as a matter of legal doctrine, it's not really too debatable that the conduct is illegal, and that even that those who are facilitating or inducing that conduct face some form of liability. So I suppose the answer, whether it's a legal answer or a technological answer, the so-called answer to the machine is in the machine, but then there'll be another machine, is not entirely encouraging, which leaves attitudes. To what extent is it possible to persuade people or to get people to understand that that not only is this illegal, because I think to an increasing extent people, at least under the age of 25, don't care that it's illegal, but that it is wrong. Now, on my tour of New Zealand law schools, I had a really interesting session at Canterbury, where I met with students because it wasn't yet exam period. Most schools, the students have been taking exams, or I gather here just finished taking exams. Those students were by and large a group of completely unrepented, unreconstructed file sharers. They were fully aware that what they were doing was illegal. And the justifications that they offered were, well, there's the sort of the Robin Hood justification, which is, Lord makes enough money, so it doesn't really matter if I'm downloading her songs. Or a slightly more sophisticated version of that is, we all know that the authors and performers aren't the real economic actors, because the record companies have already ripped them off. So if I rip off the record companies, that's somehow a blow for social justice, because I'm not hurting the authors. The record companies have already stiffed the authors. So that's another version of the Robin Hood justification. I don't think any of them really believed that, but sort of.
There's also the Rosa Parks.
What?
Rosa Parks justification. So,
Standing up to the man? Or?
a systematic form of civil disobedience in protest of unjust laws.
Protest of unjust laws, but I don't know that any of those students thought that copyright was unjust. They just like getting stuff for free. They were quite upfront about it, and they said, well, I've got a limited budget, and I could spend it on buying music, or I could spend it on lollies. Right? If I don't really have an option of getting the lollies for free, but if I can get the music for free, then I can retain my lolly budgets. And I think that the nub of it is what a an American Pulitzer Prize winning historian recently gave a talk at Columbia Law School about in a symposium called "Creation is Not Its Own Reward: Making Copyright Work for Authors and Performers," that there has not really been enough attention given to people who create works for a living. And this particular author said that he thinks that one of the problems is what he referred to as literary Luddites. Now, I had thought that usually the label Luddite is attached to people who are anti-technology. So it's kind of it's the Authors Guild are the Luddites for suing Google. But his argument, which I thought was actually quite clever, was that the people who happily download stuff, take it without paying for it, it's because they do not perceive that a work in digital form is a thing of value. They understand that the lolly is a thing of value, because the lolly is physical. And the people understand that if it's something that's a physical copy, a physical anything, that there is value that's attached to that. But if it's in a form that is so easily reproducible and so easily communicable, somehow it loses all of its value. It's the same work. It's the same book, it's the same song, whether it's in digital form or whether it's in some form of physical instantiation, but there's just a total change of attitude, that people do not perceive that there is value, they don't think that they're taking anything, or even if they think they are taking anything, it doesn't really bother them that they're taking anything, because somehow the same moral qualms that one might have about taking something in physical form doesn't translate to the dematerialized digital world. And it may be that until the disconnect is repaired, until people perceive that a work of authorship is a thing of value, regardless of whether it is in purely digital form or is in some kind of physical casing. Right? It's still a thing of value, and therefore one shouldn't just take it, even if one can. And that's the hardest part, I think. But I think these kids were refreshingly honest, in which, that none of them made the Rosa Parks argument. They sort of limply made the Robin Hood argument, but none of them said that copyright was unfair or unjust. They just said that they could get away with it. And this is somewhat troublesome. So I asked if any of them had yet taken legal ethics, which none of them had. And maybe it's also sort of generational, that there comes a point when maybe if you have to earn a living for yourself, you might start to respect other people's needing to earn a living. But until that point, there seems to be a rather large population that is quite happy to not to make the connection between value and creativity, regardless of the format in which it exists.
My question is that it's more that I think it's not just the Rosa Parks, and it's also a matter of some publications or books, especially, or they can be very pricey. I mean, it becomes a privilege to get knowledge, and that's probably what makes people want to access knowledge. I'm talking about not the young, that's just purely still stuff, but many countries like in New Zealand, for reason of trade, I suppose, books are incredibly expensive, while in UK, for example, they publish in different formats and different range of prices, so you can find a fiction book for very cheap price and everybody can access that. So knowledge should be a privilege up to a certain point, because you can honestly, if you read like 5 books a week, you can't pay $50 for a book.
Well, it used to be that's what libraries were for.
Yeah, but New Zealand hasn't got many books, for example, in the library. It's not like the British Library in London, or what if you can't find a book? I'm just arguing here. I'm not saying what do you do? I mean, and in the book, in the library, you can access one copy. What if the copy is taken from someone else and you need the book?
You have to wait, right.
You have to wait. So it's a little bit. It should be a privilege up to a certain point, I guess, probably. Like make the books more affordable for everyone. That would probably.
Mm-hmm. Right, but here's the, are we going to have an income test? That is.
No, but.
Right,
it's-
but here's the thing. It is, as a matter of technology, it is possible for a digital copy to be made available to anybody, simultaneously to everybody who has internet access anywhere in the world, right? So one copy has the technological capacity of, in effect, turning into X million copies. Right? At which point, if only one copy is sold, that's not a really successful business model.
No.
So you're saying that for countries or people who can't afford the regular price, well, in fact, there already are mechanisms in the international system to provide for cheaper prices, but I'm just thinking about how are you going to construct a system where you will make books available, or content generally available in a way that people who couldn't afford to pay full price or subscription or whatever would be able to get the subsidized price, and make that stick. Otherwise, everybody gets the book, if not for free, at the bottom price. So how is one going to make it work in a way that won't be circumvented, right? Because in fact we do as you said in Britain, this is the case, and it's the case in many other countries. I don't know about the market in New Zealand, that in fact content owners do make works available at different price points for different levels of access. Right? So you might pay full price to have a complete retention copy. So like the old days, you buy a book, you have it forever. But you can also acquire the book as sort of a digital lending, in the sense you keep it for a week and then it disappears. Or pay-per-view. You have 48 hours in which to watch the movie on television, or you can watch it 3 times or whatever it is. All of those formulas which give people different levels of access at different price points all depend on some level of technological protection. But that is circumventable, even if, as a matter of domestic and international law, it is illegal to circumvent those protections. Nonetheless, those are, it's not that hard to circumvent, and all you need is one copy to get out of the wild, and then we're in your universe. So it gets back to this question of, regardless of one's sense of entitlement and the imperatives of access to culture, there's the countervailing, I think, countervailing imperative of respect for creativity.
Yeah.
And we have not sorted that out yet.
Claire?
I think earlier on, so first of all, thank you for a fascinating talk. It was really, really interesting. And I'm in the law faculty, and one of the papers I took is human rights. So I think you said earlier on that Victor Hugo expressed that authors' rights as human rights?
Mm-hmm.
Yeah. So I was wondering if you agreed with that, and how you might see those rights expressed in human rights terms? Because you just touched on it in the last minute or so in terms of respect for creativity.
Right. Well, in this, I defer to your compatriot Graham Austin, who has written quite eloquently on this, including co-authoring a book. But I think the basic proposition is that copyright is a human right because copyright is what makes it possible for authors to earn a living, often not a particularly glorious living, eke out a living more often than not from what they create. And that states that don't want autonomous authors don't want copyright because they want to starve authors, to make it very difficult to produce works of authorship. Now, obviously, when there are kinds of works of authorship that can be created for very low cost, and perhaps you don't have to earn a living from that, you'll earn a living for something else. But if we don't have a system basically market driven that protects works of authorship, you'll still have blogs, but you may not have much more than blogs. And we do have some more historical evidence of that from that. It goes back to the French Revolution when they abolished printing privileges, right? Because privileges that was the old royal system. And so we shouldn't, there should be no restraints on publication. The only problem was that when there were no restraints on publication, there was also insufficient security to make the investments in printing anything more than broadsides. And so it was Condorcet who originally had been an advocate of eliminating all restraints on publication, who collaborated on a first draft of a copyright law in order to provide the income security that would get people to engage in more long haul endeavors. So we have some evidence of what happens if there isn't at least the prospect of security. And we also have this afternoon I adverted to Lord Macaulay, who is often quoted selectively in his great speech against the extension of the copyright term in Britain. He is often quoted as saying that copyright is exceedingly bad because it is a tax on readers for the benefit of authors. But then the second part of his speech tends to get left out, in which he says we must have a supply of good books. Right? And how are we going to do that? The least objectionable way is copyright, because the alternative is patronage. And patronage, he says, there's no sure way to turn, I forget exactly, but he didn't say upstanding citizen, but something along those lines, into a pest. Right? Because if patronage means that you are relying on the state for your funding, or you're relying on rich patrons. And that seems to me to be in some tension with the idea of freedom of expression. So I think that's why Victor Hugo said that monarchs hate literary property because they don't like authors who are free.
Brad?
You had mentioned Lord, and obviously with digital copyright, music is sort of front and center in that battle. And there was news this week when Taylor Swift pulled her entire catalog from Spotify. And other popular artists have made that same argument, although none have done that yet. And her public statements are along the lines of, I'm tired of being ripped off. These online services don't pay us nearly enough.
Mm-hmm.
And I'm just wondering what you feel about that, because she seems to be saying, well, of course she's entitled to a profit, but by all accounts she's making an enormous profit from whatever sources she's getting it, and when you're online, you're getting a much larger distribution network than you would otherwise get. So I think it'll be interesting to see where that goes if other artists follow suit. I doubt that they will.
Well, a lot of people thought that Spotify was an answer to rampant file sharing, in that that people will steal stuff if there is not a convenient and reasonably priced alternative. So, because I suppose that maybe there's some qualms about stealing stuff, and so a variation on the why I steal stuff is, I would pay for it if there was a reasonable way to get it. If I could get a good all-you-can-eat subscription or something like that. And so Spotify was supposed to be an answer, that was going to be the convenient, reasonably priced alternative that would wean people off of file sharing or now illegal streaming sites. The problem is that to get the price down to a price that appeals to the subscription base, it's a pretty low price. And there's a lot of content, there's a lot of creators who have to get paid out of that pretty low price. So the divergence between what a performer or an author or a songwriter would be paid for a platinum, you say a record goes platinum, the songwriter would have gotten $38,000 for a platinum record, and for the equivalent number, 1 million streams, you get 38 cents. Right? So there's a little problem there between $38,000 and 38 cents. So that, so there's been a lot of unhappiness expressed about that. So is the problem that it's not, there's a difficulty finding what is the right price to keep people buying a subscription, but yet generate enough money? Is the problem that it's not so much the price, but who gets what percent? Is because maybe the record companies are getting the lion's share of that subscription price, or Spotify is getting the large. So I think there's two pricing issues. One is the size of the pot, and the other is how that pot gets divided up. But it's true, there's just a tremendous difference in what the income that one gets from digital as opposed to the income that one got from hard copy distribution, to which the answer might be too bad. The era of hard copy distribution is over. You might have made $38,000 for 1 million CD sales, but nobody buys CDs anymore. So it's not really helpful to look back at how much money you made under a business model that doesn't exist or is on its way out of existence. So comparing the CD sales with streams is obviously it can make one unhappy, but it's not helpful.
You've got a final question? Yes.
Just as a librarian,
Yes.
I think libraries have always been happy to and believe in paying a fair price for works.
Mm-hmm.
I mean, without authors, we don't exist,
Mhm.
really. So, do you see that there is a model that will balance that authors' rights and libraries providing the access to those who can't afford it, being able to sort of even out that the access to highly popular works that may be digitized illegally,
Mm-hmm.
to those, particularly in the academic library, that may be very valuable scholarly works, but are never going to be used by hundreds of people, and can cost hundreds of dollars
Mm-hmm.
per single title. So do you see there being a workable model for that?
I don't know to what extent the public lending right is a partial answer. For my own country, we don't have a public lending right, And I can't imagine, especially now that the Republicans have complete control of Congress, that we're going to have a public lending right, because the public lending right means that the state is compensating authors and publishers for the services that libraries provide, right? And in the United States, we really don't believe that the state should do anything other than build roads and ease gun restrictions. Sorry. So the public lending right may be a partial answer in some countries, but not necessarily everywhere. I think actually on academic books, I see a different future than the one that we've been living in. Right now, there's a relatively small number of academic publishers that do have a stranglehold on publishing and jack up the price terribly. To some extent, services like JSTOR alleviate that, but JSTOR doesn't make the content available until after, I think it's at least 12 months. I forget what the moratorium is before you can get back issues on JSTOR. So if you want current stuff there, you've still got a problem. But I think that that problem is also largely of universities' own making, because the reason that those academic publishers have such a stranglehold is that universities have effectively outsourced credentialing to the peer-reviewed journals. And if universities would do their own work in credentialing, then they wouldn't be in such a dependent relationship with the peer-reviewed journals. This is doable. It's doable today. It was doable years ago, but universities have not been particularly willing to undertake that role. But since it becomes, since academic publishers are not needed for the material aspect of publishing, many journals now are digital only anyway. You don't need the publisher to do the work of production and distribution that publishers used to do. So there are other valuable roles that publishers play. Those include credentialing or screening, which remains important. In academic publishing, they don't have to worry about accounting to authors because they don't pay the authors any royalties. On the contrary, sometimes the author has to pay the journal to get published in the journal. And so it's like a double whammy. The academic pays the journal to get published in the journal, and then the institution pays the journal a subscription in order to have the subscription. So that's a role that accounting and paying to authors is not a role that academic publishers play. And another really important role of publishers, which academic publishers also don't pay, is that for professional authors, in other words, authors who don't have university salaries but actually have to live by what they write, it takes a while to write a book. And so a trade publisher provides an advance against royalties. And the author lives on the advance against royalties until the book is published. That's a really important publisher function, which just doesn't apply in the academic publishing world. So there's a great deal, if I were worried, if I were thinking about which business model is or should be in trouble, I might say that academic journal publishing is a good candidate, and the only thing that's propping it up is the peer review function. That's maybe overstated and provocative, but if peer review were not the primary purview of those journals, there would be really no basis on which they could be charging those subscription fees.
And on that cheerful note, it's It's been a fascinating as well as a provocative discussion. You've brought us all the way back to the age of the pharaohs in Alexandria up to current day of the challenges of file sharing and knowing engagement in criminal conduct
And I didn't
on the
even
part of
mention
law
Kin.com.
students in New Zealand. So, yes, and you never mentioned that other individual with the who's changed his official last name. It's only dot that we've got that actually spells it D-O-T in the world of the internet. But let me ask you all to thank Professor Ginsburg in an arm away for such a wonderful talk. Small gift for you.
Oh, thank you. Is this a Waikato merchandising property?
No,
It's
it's
not.
not.
Oh, very nice. Thank you.